application and appeal in the matter of Altrad Services Ltd and another SGLJ.
Yes, good morning.
Good morning, my lords and lady. On the application that concerns Mr. Davies' half of the case, as you won't be at all surprised to hear, there's a division of labour on this side of the court, and I'm going to be dealing with ground one or issue one, and Mr. Davies is going to be dealing with issue two. And we thought, obviously subject to the court's wishes, that we would ask you to allow us to make the application, or make Mr. Davey make the application when it comes to his part of the case.
Yes, I think that's
I'll crack on.
Probably sensible. We can crack on with ground one.
Yeah.
Just before we start, I approved a transcript. Is there going to be a transcript? There is.
As far as I'm aware, yes.
Yes.
So much? Yes.
Yes. As long as we get copies of a transcript, it saves us from having to take quite such a detailed note, and we can just listen to you, Mr. Mull.
Right. Well, as I say, I'll be making submissions on ground one, the overarching Ramsey issue, which succeeded before the first tier tribunal. I was originally then going to take the court through the whole history of the tax avoidance cases since Ramsey, but owing to the particular composition of this court, I thought I'd be teaching my grandmother to suck eggs. So, subject of course to your views, I will be making my main submissions on Rossendale and Hurstwood, which is the last Supreme Court case, and on the two very recent Court of Appeal judgments in Clipperton and Hargreaves that you will remember too well, being only earlier this year. But I will refer to particularly BMBF, which is contains important advice on the purpose of the capital allowance provisions. And Melliwish I'll be referring to because the respondents and indeed Mrs. Justice Falk, as she then was, placed great reliance on it. But if on issue one, then could I remind you of what the first tier tribunal decided on the evidence before them? I apologise if you've read and digested the entire first tier tribunal decision, but please stop me if you don't want me to go through it. But I'll try to be as brief as I can because it's central to our case is what the first tier tribunal actually found on the facts before them and then decided. And if I
think you can take it. We have probably read both tribunal decisions, but
yes.
It would be helpful if you highlighted
yes.
those parts which we should pay particular attention to.
Yes, certainly. I would in particular emphasise paragraph 23.
Do you have a page number?
Yes. Well, it's behind tab 20 of the core bundle, and I think it's page
196.
I'm grateful. So that's where the first tier tribunal conclude that on a purposive approach to the interpretation of the relevant provisions of the Capital Allowances Act, viewing the overall effects of the transactions as they were intended to operate as a composite whole, the appellants did not A, dispose of the assets for the purposes of section 61 when they sold them to the bank, B, incur any qualifying expenditure under the funding lease regime on entering into the leases or make a disposal of them on the expiry of the leases, or C, incur any further qualifying expenditure when they reacquired the assets from the bank for the purposes of section 11. And of course it's A, which I shall be concentrating on. They didn't dispose of the assets for the purposes of section 61. And then we get to paragraph 24, where the tribunal sets out section 11.4, and it's which says that the general rule is that expenditure is qualifying expenditure if A, it is capital expenditure on the provision of plant or machinery, wholly or partly for the purposes of the qualifying activity carried on by the person incurring the expenditure, and B, the person incurring expenditure owns the plant and machinery as a result of incurring it. And then paragraph 26, the Tribunal set out section 61, and there you have 61(1)(a), with which we're concerned, the person ceases to own the plant and machinery. And just relevant to go on, the person loses possession of the plant or machinery in circumstances where it's reasonable to assume that the loss is permanent. Or C, the plant and machinery has been in use for mineral exploration and access, and the person abandons it at the site where it is in use for that purpose. And D, the plant and machinery ceases to exist as such as a result of destruction, dismantling, or otherwise. And it will be our case that you don't cease to own the plant and machinery when, in fact, as part of the same series of exercises, very shortly after a ridiculously short time, you, on any view, own it again. And any more than, for example, looking at little d there, if you dismantle the plant and machinery and then the following week reassemble it, you would not expect to have a disposal event under 61(1)(d). So that's the provisions that we're looking at. And then at paragraph 37, the tribunal sets out the particular plant and machinery that we're talking about here. The transactions under consideration in its appeal relate to assets such as scaffolding, stock and ancillary equipment, pumps, cleaning equipment, heaters, tractors, trailers and testing analytical equipment, in each case used for the purposes of its trade. Of course, in this case we're talking about equipment that the appellants had long since acquired for the purposes of their trade, had been using in their trade and continue to use them throughout the events that we're about to discuss. Similar equivalent paragraph for Wiseman is at paragraph 54 of the decision. At the time of the transactions under consideration, the appeal made by Wiseman was a subsidiary of Robert Wiseman Dairies, which was a major supplier and distributor of milk. It was common ground that the assets which were the subject of the Wiseman transactions were in use in the Wiseman Dairies group's trade in the collection, processing, packing and distribution of milk and milk products. And there is in the supplementary bundle, I'm not asking you to look at it, but at tab 3 in the supplementary bundle, pages 54 to 82, set out all the different equipment that was already in use in the dairy operations of Wiseman, refrigerators in particular, as you might expect, and they are the subject of this. I think there's 28 pages of equipment that are the subject of this scheme. So that's what we're talking about. That's the plant and machinery that, and the question is, have Altrad and Wiseman ceased to own that during the 3 or 4 weeks of that the scheme took to roll out.
So it's an important part of the background. I take it you would agree that the status quo is all the equipment we're talking about is already in use.
Yes.
And is already operating perfectly satisfactorily within the statutory regime.
Yes.
In accordance with the terms laid down by Parliament, whereby allowances are given and so on, and,
yes,
and all the rest of it.
Yes. They're already getting allowances on that equipment.
So we're looking at a scheme which is a bolt-on, which is
yes,
intended to provide an additional
exactly
increase in
yes,
modifying expenditure without anything changing in the real world.
yes, and as indeed Mrs. Justice felt, which then was said in her own judgment, although this is only done once, this bolt-on, if the taxpayer is right, it could have been done every 3 days until the law got changed, and so they could have had multiple capital allowances and reduced their corporation tax bill to nil.
I mean, subject to steering clear of sham, you repeated them. You could do it daily, I imagine.
Yeah, well, we've never argued it's sham.
No.
They went through all the details, but we do say that Parliament certainly didn't intend there to be multiple capital allowances on the same bit of machinery, which is the result of this scheme succeeding.
In this case, there's no question of these assets being fixtures, and you don't get into that problem. That,
No, we're not on the fixture problem, no.
they're all chattels.
They're all chattels, yes.
Thank you.
That's right, isn't it? You know, there are things like lorries and things like that, and milk fridges and that sort of stuff.
Well, you can imagine that things like fridges could be freestanding and they could be built in, but
Yes.
but in this case, there's no question of fixtures that has been raised or anybody wishes to raise.
I believe so, that's right, yes.
Thank you.
As I say, there are schedules of these different bits and pieces that are part of the scheme, which look to me as if they're all not non-fixtures. I think certainly Hurstwood and Rosendale does involve fixtures, and we'll come to that in due course. Right, so that's that. So then paragraph 70 was the next paragraph of the first tier tribunal I wanted to draw your attention to, which is on page 23 of the decision. I note that under the arrangements described above, the appellants each realised part of the cash value of their assets. Mr. Peacock said in his skeleton argument that this conferred a real commercial benefit on them. However, it is clear that obtaining short-term finance for use in their business was not the appellant's purpose in entering into these transactions, and they did not, in fact, receive any financial benefit other than the ability to fund the option price or at least some of the rents. And then at paragraph 75, she concludes on the commercial purpose element. In any event, my view is that it is plain from the design and economics of the scheme that the appellant's sole purpose in entering into the various transactions was to obtain allowances on the option price without suffering the economic burden of paying that amount. This appears to accord with the views of the appellants and their advisors as reported in correspondence and meeting notes as set out above. It appears from Mr. Peacock's responses to the questions asked at the hearing that the appellants were not making any submission that the appellants had any other purpose in entering into the arrangement, and as noted, no evidence was produced which would support any contention that they had such purpose. And just referring back, if I may, to the views of the appellant's advisors, that in particular is at paragraph 40, subparagraph 2 of the decision, where it says KPMG advised that CIS, which is the Altrad, should not recognise the sale of the assets, but should continue to keep the assets on its balance sheet and account for them as previously. So that's what the First Tier Tribunal found on the facts before it. Then we go on to Part D of the Tribunal's decision, which starts at 76. That's the HMRC's submissions, and indeed exactly what I say to you now. The 76.2a, when the appellant sold the assets to the bank, SGLJ, I'm going to call it the bank, they did not cease to own them for the purposes of section 61(1)a. Correspondingly, the subsequent events do not have the tax consequences which the appellants described. And then paragraph 79, I set out the...
Can I just check, just before you move on from 76.2a, that's your ground one,
Yes,
that the
that's
appellants did not cease to own them.
Yeah.
Is it accepted that if you were to succeed on ground one, then the consequence in 76.2b would follow, that the subsequent events wouldn't have any tax consequences?
I hope so. That's something from Mr. Peacock, but I think that's the way it's been treated so far. Yeah. And then 79, in particular, I'd emphasise, if I may, that there were as you will have seen, there were two possible arrangement fees for the bank to get, and it was getting one arrangement fee at the beginning of entering into the scheme, and it was only going to get a second arrangement fee if it exercised the put option to sell back to the original company the plant and machinery. It was essential, as we say at 79.3, as I was arguing that, it was essential for the taxpayer to work in the way hoped for that the put option was exercised. The bank only got its second arrangement fee if it exercised the put option. There was a call option there for the Altrad or Wiseman companies to exercise to call it back, but that was going to be exercisable by the parent company of their group, and it wouldn't actually work if they did it that way. So it was essential for the taxpayer to work that the put option was exercised so that the original company got its plant and machinery back, and the bank was going to get a very substantial second arrangement fee for exercising the put option. So obviously it did exercise that, and so then that led me at 81.1 to be arguing, as I do now, on a realistic view of the facts, having regard to the operation of the composite scheme as a whole, the appellant did not cease to own the assets when they sold them to the bank, and therefore did not dispose of them for the purposes of section 61.1a. And if I could just carry on to 83 of the first tier tribunal's decision. 83 paragraph 3, the appellant's construction of section 61 would lead to an anomalous outcome that Parliament could not rationally have intended. See the Court of Appeal decision in Shop Direct, which you may remember, where Parliament couldn't possibly have expected, in this case, multiple capital allowances to be available. And then at 98, yes, I emphasise then and as I do now, we're not arguing that circularity means this is not effective. The argument here is there's no cessation of ownership of the assets for purposes of 61.1a as properly construed, and then any subsequent change in legislation is irrelevant. I mean, as you may or may not know, since this scheme happened, there has been quite a lot of anti-tax avoidance legislation, which has meant that schemes of this sort are not being done anymore at all. This particular scheme was stopped in subsequent legislation. I mean, it was at one stage thought that the judges had a handle on it, but then there was a case called Mays, which went the way of the taxpayer, and I think it was that meant that encouraged the government of the day to introduce the General Anti-Avoidance Rule, or GAR as we call it, which has effectively put a stop to imaginative tax planning of this sort. So we are
when did the GAR come into effect?
2014 was it? I'll be corrected about that, yes.
2013.
What?
2013.
13. July 2013.
Thank you.
That's what. So this is a pre-GAR case.
The pre-GAR case.
Which explains the complete absence of any reference to the GAR in any of the
Yes.
papers.
Yeah. So then there's an analysis of the case law in the first tier tribunal's decision. As I said, since then we've had since the decision in this case, the first tier, we've had Rossendale and Hurstwood, we've had Clipperton, and we've had Hargreaves. So although I entirely commend the analysis and don't want to in any way detract from it, quite the contrary, I as I say, respectfully adopt it all, but I won't take you through it all again. Your lordship say you've read it already, and as I say, it is. We've had so much recent legislation, recent case law on it that I think I can safely concentrate on those three cases: Rossendale, Clifton, and Hargreaves. So there is one section though of the first tier tribunal that I would like to emphasise again, which is the one about the purposive approach to the Capital Allowances Act, which starts at paragraph 245. The tribunal had a section on approach to statutory interpretation, but then at 245, the tribunal turned to the provisions under consideration here, as Lord Nichols set out in Barclays Mercantile Business Finance, or BMBF. The purpose of the capital allowances regime, as it relates to writing down allowances, is to provide the tax equivalent to the normal accounting deduction from profits for the depreciation of machinery and plant, which is used for the purposes of a taxpayer's trade. It's essential to a taxpayer's entitlement to claim allowances under Section 11 that, as these requirements have been interpreted in cases such as Ensign and Tower, it really incurs capital expenditure for the real purpose of acquiring an asset for use in its trade, and it owns the asset as a result of incurring the expenditure. Now, I emphasise here, as I will again, here, that this case, our case, is about what is ceasing. We're not arguing about the meaning of the word own, or indeed the meaning of the word belongs, which we'll come to when we look at Millish. We entirely accept belonging and owning mean the same, but what we don't accept is there's any cessation of ownership in this particular case. I respectfully adopt the whole of paragraph 245 through to the end of that, or the end of the decision, really, that it's 245 through to 259 is about the purpose of the Capital Allowances Act, and then at 260 the tribunal conclude, just having had said that the scheme could have been repeated any number of times until the law was changed. 260, tribunal says, in conclusion, in my view, on a realistic and unblinkered view of the facts, having regard to the effect of the composite transaction as a whole as described above, the provisions of section 61(1)(a), the relevant funding regime rules, or section 11, were not engaged to give the effect the appellant said applied. One, on the sale of the assets to the bank, the appellant did not dispose of the assets for a disposal value for the purposes of section 61(a), viewed in the light of the overall context in which that provision operates and in the light of the other disposal events, it seems to me that the reference to a cessation of ownership in subsection 1A implies that for that provision to operate, it is not sufficient for the taxpayer to give up or lose the bundle of rights and liabilities characteristic of ownership in legal terms, if, as is the case here, it does so with a certain knowledge that, barring a wholly unforeseen event, it will reacquire ownership within a matter of weeks. And two, the temporary loss of ownership was effected as the first step in a composite scheme, each element of which was carefully crafted to ensure that the scheme would operate to deliver additional magical qualifying expenditure for the taxpayer of £95 without it suffering an actual cost of that amount. In other words, there was no such cessation of ownership on a sale of assets which was effected to generate a loss of ownership, which it was known from the outset would be a very short period only as an essential ingredient in an artificial construct to manufacture qualifying expenditure. And that of course, is what I adopt as my argument here, word for word. 264, paragraph 264. In these appeals, on the required close scrutiny, we are concerned throughout with the appellant's own acts and purposes in assessing whether A, when the appellants sold their interest in the assets to the bank, they ceased to own them within the meaning of 61(1)(a), B, B, when immediately afterwards they entered into the leases and granted the put options, they incurred qualifying expenditure under the long funding lease regime. And C, when they reacquired the assets on paying the option price, they incurred qualifying expenditure for the purposes of section 11. 265, unlike in BMBF, Ensign and Tower, as set out in full above, the appellants had no commercial or business purpose at all in entering into any of these steps, other than through their combined operation as a carefully constructed commercial unity to generate additional qualifying expenditure in respect of the assets without the appellants incurring any further actual financial costs. And then almost finally, 272, having regard to the purpose of the legislation for similar reasons as those given in Ramsey, it would be wrong to pick out and stop at one step in the combination of the single continuous operation which produced the supposed tax benefit. The creation of the qualifying expenditure was entirely dependent on the prior taxable disposal of the assets, which, like the gain in Ramsey, was intended to fund the creation of this benefit, but not lead to any adverse tax effect. The true view is that there was no disposal of the assets within the meaning of section 61, no incurring of expenditure under the leases within the meaning of the funding lease regime, and no incurring of qualifying expenditure within the meaning of section 11. I note that, as in Carreras, the objection could be raised that this conclusion raises uncertainty. The question arises of whether the conclusion would be different if, for example, the assets were leased to the asset user for a much longer period of time before the asset user reacquired them. However, as Lord Hoffman said in Carreras, it is inherent in the process of construction that one will have to decide as a question of fact whether a given act was or was not a part of the transaction contemplated by the statute. And as he said, in practice, any uncertainty is likely to be confined to transactions in which steps have been inserted without any commercial purpose, and that uncertainty is something which architects of such schemes have to accept. So, we haven't had a look at Carreras, but we could have a quick look at it at one point. That really is the meat of the first tier tribunal that I wanted to just underscore for you. And just as a very last hurrah on that, just turning back to 271, similarly, for the reasons set out above in assessing whether on purpose of approach the appellants may dispose of assets for disposal value and reacquire the assets on incurring qualifying expenditure, the relevant fact on which it is necessary to focus is the overall economic outcome of this closely integrated set of transactions. In economic terms, at the end of the transactions, nothing had happened except that the appellants had paid some fees and expenses in order to generate, quotes, qualifying expenditure, close quotes, without suffering the financial burden of that expenditure. So we say that with respect that the first tier tribunal's decision is impeccable, and I would ask that it be upheld. When we come to the Upper Tribunal, we set out their summary of the facts in an overview of the arrangements that we set out at the beginning of our skeleton argument, paragraph 4, paragraph skeleton argument, and it's important that I make this particular point, that we set out that the Upper Tribunal's summary of the scheme, and paragraph 16, set out in paragraph 4 of our skeleton, they say each taxpayer sold the assets to a leasing company in the banking group for their market value of £100, and as a result ceased to be the legal or beneficial owner of the assets. Well, as you've just seen, it's not what the first tier tribunal said, and hopefully the Upper Tribunal weren't prejudging the case on that basis. They do say when you get to the nitty-gritty of the Upper Tribunal's decision, they seem to be basing their decision on what the First Tier Tribunal said at paragraph 258 of the decision. Where I read to you the 258 of the First Tier Tribunal decision, they gave up ownership of the assets subject to these facts with the attendant legal and commercial effects that entailed, but they only did so to generate the desired allowances, and it appeared for the bare minimum of time considered necessary to achieve that result. In economic terms, they incurred no material costs other than the fees due to the bank and other expenses associated with implementing the transactions. So, and that then was upon which the main ground of the Upper Tribunal's decision. The Upper Tribunal say it follows from that decision there, that paragraph of 258 there of the First Tier Tribunal. There we've ceased to own the asset. But we say, of course, that's not what the First Tier Tribunal was saying. They weren't saying they ceased to own the assets within the meaning of the section 61(1)(a). They especially say gave up ownership just subject to these with the attendant legal commercials for the bare minimum of time thought to be necessary to achieve that result. But we say that that's certainly not effectively giving up the whole of ground one. We'll see what the Upper Tribunal will say about that in due course.
And this is a problem which one always encounters when you have an argument that steps in a composite scheme should be disregarded, because if you look at it with tunnel vision and in isolation,
yes,
it's obviously right. There was a sale. Nobody's saying it was a sham.
yes,
From one point of view,
yeah.
that indeed was its effect.
Yeah.
But the point is, if it's looked at as part of the composite scheme construed, it takes on a different colour.
Absolutely.
Or at least, I mean, that's, as I understand it, that's what the FTT was doing.
Yes, exactly.
The writer may temporarily have taken her eye off the ball at this particular point, but overall there can't be any serious doubt that that was her analysis. And I take it that's really what you're trying to persuade us to adopt and approve.
Precisely, my lord.
It does, there's always this air of, well, to me anyway, it's always been one of the difficulties of the Ramsey doctrine. I'm not saying it's in any sense not now firmly and well established. But one does have this tension between the legal characterization of the steps viewed in isolation and the characterization of the scheme as a whole.
Indeed, as you also well remember, there were
well, I
some
mean,
decades when it was going backwards and forwards.
Perhaps a classic example, I'm sure we'll be going on to that, where if you viewed in isolation, it was perfectly obvious that the leases in question were not sham, and they did indeed confer possession on the tenants. It's elementary landlord and tenant law.
Yep, absolutely.
That was not the right question, as the Supreme Court told us and me in particular.
I'm grateful, my lord. So, yes, it's the Upper Tribunal's decision at paragraph 93. Then, if you have that to hand, it's in behind tab 2 of the core bundle. So, no, sorry, it isn't. So it's, where is it?
Core bundle
Big
16.
16 of the core bundle, yeah. Paragraph 93 of the First Tier Tribunal's decision, where having set out all the various case law, etc. 93, the Upper Tribunal say, in the light of the conclusion we've just expressed, the relevant question for the First Tier Tribunal, given the way in which HMRC chose to put their Ramsey argument, was whether the appellant lost legal and beneficial ownership of the assets when they sold them to SGLJ, the bank. The First Tier Tribunal answered that question in the appellant's favour at 258. Well, we've just seen 258. If one reads the First Tier Tribunal's decision as a whole, it's very difficult to see that that was a point made in the appellant's favour, and if one goes on to 260, as I've just shown you, it's quite clear that they weren't in the appellant's favour when they said what they said in 258. But the Upper Tribunal continuing to say, in the light of that finding at 258, it should have concluded that the requirement of section 61(1)(a) was satisfied. The First Tier Tribunal wrongly considered that its findings as to the composite nature of the subsequent transactions and the appellant's purpose in effecting those transactions led to a different result. The problem with the First Tier Tribunal's conclusion was not that its factual findings in this regard were wrong, rather they were not relevant to the inquiry that section 61(1)(a) include purposely required. Well, with great respect, I submit that the First Tier Tribunal were exactly right in their approach to that, and that they were entirely justified on the facts which they had found, which, as the Upper Tribunal made clear, were not in dispute at all. Then the First Tier Tribunal were right in deciding that there was no cessation of ownership within the meaning of section 61(1)(a). Now, in our skeleton, we go through the cases from Ramsey onwards. Ramsey, we mentioned at paragraph 9, BMBF, UBS, and Rossendale and Hurstwood at 12. As I said, I'm not going to drag you through everything, but I think I ought to show you BMBF, which is at tab 30.
No, just before you go there,
Yes,
could
yes.
I just pick up, before I forget really, a point
Yes.
which I wanted to raise at some point about the footnote, right at the footnote 1, right at the beginning of your skeleton. It seems to me a bit puzzling. It says, although formally appeals to the court particular from decisions of the Upper Tribunal, the substantive question is whether the FTT was entitled to reach the decision that it did, and then the case is cited, which I'm afraid I haven't looked at. But I mean, here we're just these are questions of law. It's not a question of whether the FTT were entitled, it's just whether they were right or wrong.
Oh, yes, sorry, yes. Yeah, I didn't mean to say it was.
It's not like
I
a
think-
multifactorial evaluation type of case.
I think what my Lord Justice Nugee was saying in Dolphin Drilling is that we needn't concentrate too much on what the Upper Tribunal necessarily said. We've got to decide on the law what the answer is, taking the facts, undisputed facts, as found by the First Tier Tribunal.
I think
sorry.
actually in dolphin drilling,
Yes.
the question was whether something was incidental to something else, and that was a multifactorial
Absolutely.
evaluation. And the FTT said one thing, and the question for us on appeal was whether the FTT was entitled to come to that conclusion, because if it was, the UT shouldn't have interfered with it, but if it wasn't, UT was right to interfere with it. And as my Lord points out, that's not quite the same here.
No,
We're not asking whether the FTT's conclusion was one that was open to it, but whether...
No, I take that. I'm grateful. Cool. But what I'm not proposing to spend a great deal of time analysing the Upper Tribunal, because the Upper Tribunal were basically expressing a view of the law, which we're now asking you to express. So,
Yes.
First, I'm very happy to go through it if you wish, but and things have moved on, frankly, even since the Upper Tribunal decision. We've had both Clipperton and Hargreaves. The judge who wrote Hargreaves was Lady Justice Felk, which is interesting from our point of view. What I was next going to do is to take you to BMBF, because that is the origin of the learning on the purpose of the capital allowance legislation. That's at tab 34. which is in the second bundle of authorities. And if you have that, it concerns whether a Barclays Group company could claim capital allowances that it asserted it was entitled to under a finance leasing transaction. The parties also referred to the earlier decision in Ensign Tankers and the later one in Tower and Cashback, which both relate to the availability of allowances in asset finance transactions. And the facts are set out there in the head note. I don't know whether your lordships are familiar with this case, but what I was particularly wanting to look at was Lord Nichols at paragraph 3 of the judgment of the court, which is at page 528 of your bundle. Which says a trader computing his profits or losses will ordinarily make some deduction for depreciation in the value of the machinery or plant which he uses. Otherwise, the computation will take no account of the need for the eventual replacement of wasting assets, and the true profits will be overstated. But the computation required by Schedule D, whether for the purpose of income or corporation tax, has always excluded such a deduction. Parliament therefore makes separate provision for depreciation by means of capital allowances against what would otherwise be taxable income. In addition, generous initial or first-year allowances exceeding actual depreciation are sometimes provided as a positive incentive to investment in new plant. So that's the purpose of capital allowance provision, to give you a relief for expenditure on plant and machinery that you acquire for the purpose of your business, which would be capital expenditure and therefore not normally deductible under Schedule D. In this case, both the taxpayers have already had capital allowances on the expenditure they've incurred for on all this equipment for the purpose of their trade. And what they're wanting is to have a double dip, or indeed, as Mrs. Justice Falk said, as many times as they could get away with. So on the basis of the purpose of the capital allowances provisions, then the appellants have already had the allowances which Parliament has set out for them. Now, just while we're there, could I just show quickly paragraph 32, where Lord Nichols, giving judgments of the House of Lords, is setting out the Ramsey approach. 32, he says, the essence of the new approach was to give the statutory provision the purpose of construction in order to determine the nature of the transaction to which it was intended to apply, and then to decide whether the actual transaction, which might involve considering the overall effect of a number of elements intended to operate together, answered to this statutory description. Of course, this does not mean that the courts have to put their reasoning into the straitjacket of first construing the statute in the abstract, then looking at the facts. It might be more convenient to analyse the facts and then ask whether they satisfy the requirements of the statute. But however one approaches the matter, the question is always whether the relevant provisions of the statute upon its true construction applies to the facts as found. As Lord Nichols in McNiven and Westmoreland said, the paramount question is always one of interpretation of the particular statutory provision and its application of the facts of this case. The simplicity of this question, however difficult it might be to answer on the facts of a particular case, shows that the Ramsey case did not introduce a new doctrine operating within the special field of revenue statutes. On the contrary, as Lord Steyn observed in Hogokian, it rescued the tax law from being some island of literal interpretation and brought it within generally applicable principles. Unfortunately, the novelty for tax lawyers of this exposure to ordinary principles of statutory construction produced a tendency to regard Ramsey as establishing a new jurisprudence governed by special rules of its own. This tendency has been encouraged by two features characteristic of tax law, although by no means exclusively so. The first is that tax is generally imposed by reference to economic activities or transactions which exist, as Lord Whipple said, in the real world. The second is that a good deal of intellectual effort is devoted to structuring transactions in a form which will have the same or nearly the same economic effect as a taxable transaction, but which it is hoped will fall outside the terms of the taxing statute. It is characteristic of these composite transactions that they will include elements which have been inserted without any business or commercial purpose, but are intended to have the effect of removing the transaction from the scope of the charge. That paragraph 32 that I read to you just now, and the next paragraph I'm going to read to 36, are often quoted, indeed quoted in Hargreaves, as we'll see shortly. Paragraph 36 of BMBF. Cases such as these gave rise to the view that in the application of any taxing statute, transactions or elements of transactions which had no commercial purpose were to be disregarded, but that is going too far. It elides the two steps which are necessary in the application of any statutory provision. First, to decide on a purpose of construction exactly what transaction will answer to the statutory description, and secondly, to decide whether the transaction in question does so. As Ribeiro PJ said in Arrowtown Assets, the driving principle in the Ramsey line of cases continues to involve a general rule of statutory construction and an unblinkered approach to the analysis of the facts. The ultimate question is whether the relevant statutory provisions construed purposefully were intended to apply to the transaction viewed realistically. And if I pick up at 39, the present case, like McNiven, illustrates the need for a close analysis of what on a purpose of construction the statute actually requires. The object of granting the allowance is, as we have said, to provide a tax equivalent to the normal accounting deduction from profits for the depreciation of machinery and plant used for the purposes of a trade. Consistently with this purpose, section 24(1, the forerunner of section 11, requires that a trader should have incurred capital expenditure on the provision of machinery or plant for the purposes of his trade. When the trade is finance leasing, this means that the capital expenditure should have been incurred to acquire the machinery or plant for the purpose of leasing it in the course of the trade. In such a case, it is the lessor as owner who suffers the depreciation in the value of the plant and is therefore entitled to an allowance against the profits of the trade. And perhaps I could skip to just 42, just for E. No one disputes that BMBF had acquired ownership of the pipeline or that it generated income from BMBF in the course of its trade in the form of rent chargeable to corporation tax. In return, it paid £91 million. The secretariat of payments which show impressed Mr. Justice Park and the Special Commissioner arose because BMBF, in the ordinary course of its business, borrowed the money to buy the pipeline from Barclays Bank, and Barclays happened to be the bank which provided the cash guarantee to BMBF for the payment of the rent. But these were happenstances. None of these transactions, whether circular or not, were necessary elements in creating the entitlement to the capital allowances. So the BMBF acquired real assets for the purpose that it hadn't owned before for the purposes of its trade, and it paid £91 million for them. So it was entitled to the capital allowances, even though the money, since BMBF was a subsidiary of the bank, the money went round in a circle. So that gives you the origin of the House of Lords views on the purpose of the capital allowance provisions. And I think perhaps I ought to next deal with a case called Millish, which is in volume 1 of your bundle, tab 27, because that is a case which the taxpayers rely heavily, and indeed the Upper Tribunal relied heavily. case in 1995 in the House of Lords. And we say that far from supporting the appellants, we say, if anything, Meadows supports our case rather than the taxpayers. The very brief facts were that BMI leased equipment such as lifts and boilers to a number of local authorities, and these became fixtures, of course. They were installed in the local authorities' buildings, and an ordinary principle of general law did become fixtures. And the case was all about what is meant by belonging, which we accept common ground is the same as owning under the current legislation, but not at all about what is meant by ceasing. If I could take you to page 475 at F. Which is at page 331. It's 475 at F of the report, where Lord Brown Wilkinson is saying, I turn then to consider whether the bundle of rights enjoyed by the taxpayer companies, including the limited equitable rights which I have referred, is sufficient to justify describing the equipment belonging to the taxpayer company for the purposes of section 44. In my judgment, the factors relied upon are not sufficient to constitute belonging. The taxpayer company has never been the owner of the equipment, whether in law or in equity. It became a fixture and therefore the property of the legal authority before the lease was entered into. Unless and until the local authority is in default or decides not to renew the lease, the taxpayer company has no right to possession of the equipment or to direct how it shall be used. Its only property right is a contingent right to become the owner at a future date. In the meantime, the property is owned and enjoyed exclusively by the local authority. The fact that the taxpayer company has an equitable right which may in the future be enforceable against some third parties does not, in my judgment, carry much weight. It indicates that there are rights relating to the equipment which belong to the taxpayer company, not that the equipment itself belongs to them. And then if I could skip down to 476 between F and G. I therefore reach the conclusion that for the purposes of section 44, property belongs to a person if he is in law or in equity the absolute owner of it. Such construction reflects the obvious prima facie meaning of the word, what belongs to me is what I own. It produces a coherent and easily applicable formula, and save in relation to fixtures, avoids anomalous results. And fortify this conclusion by the decision of the Court of Appeal in Stokes and Costain. In that case, the taxpayer developed a site belonging to the local authority under an agreement which required the inclusion of certain plant and equipment as fixtures. Pursuant to the agreement, on completion of the development, the developer was granted a 99-year lease by the local authority. The developer's claim for capital allowances for the plant and equipment they had installed failed because, as a fixture, it was owned by the local authority as freeholders and could not, for the purposes of section 44, belong to the developers of leases. Lord Justice Fox said, I agree that belonging and belonging are not terms of art. They are ordinary affairs. It seems to me that in ordinary usage they would not be satisfied by limited interest. For example, I do not think that one could say that a chattel belongs to X if he merely has the right to use it for 5 years. Lord Justice Robert Clark treated the expression belonging to as the same as owned by. In my judgment, that case was rightly decided. The same conclusion must apply to the much lesser rights belonging enjoyed in the present case. A long lease holder enjoys a legal estate in the land, including the fixtures, which gives him immediate possession and enjoyment of the fixtures. In contrast, in the present case, the rights enjoyed by the taxpayer company confer no immediate right of any kind to enjoyment of the property, and only nebulous contingent future rights to do so. So that, in my respectful submission, is a very, very, very long way indeed from the facts in Altrad and Wiseman, where they do start as owners of this equipment in the first place. We're not talking about belonging or owning here. That's not in dispute. What is in dispute is whether we cease to own in the course of this particular preordained scheme. And we say that Mellivish throws no light on that question at all. With great respect, the Upper Tribunal was wrong to accept the appellants, the respondents' reliance on it. So it's that's Mellivish. Then there are, I think, as I said, I think we rely on what's said in Arrowtown, Scottish Providence, Moreras, but perhaps in view of the fact that in so many cases recently on all this, perhaps I could take you next straight to Rossendale and Hurstwood, which is at tab 46 in the third volume of Local Authorities. This is a case all about business rate avoidance, tab 46. I can just take you to the beginning of the head note of the facts. The defendants in two separate cases were the registered owners of a number of unoccupied commercial properties on which non-domestic rates were payable by the owner of the written within section 45(1)(b) of the Local Government Finance Act of 1988, defined in section 65(1) of the Act as the person entitled to possession of their written. The defendants sought to avoid liability for such rates by leasing the hereditaments to special purpose vehicle companies, SPVs, without any assets or business, which were then voluntarily wound up so as to trigger the winding up exemption to non-business, to trigger the winding up exemption to non-domestic rates, or allowed to be struck off the register of companies as dormant companies and thus dissolved, so that the leases and liability for rates passed as bona vacantia to the Crown. The leases were not shams, so as a matter of real property law, they conferred an entitlement to possession upon the SPVs. The claimant local authorities brought claims seeking recovery of non-domestic rates from the defendants, contending that, one, the 1988 Act should be given a permissive interpretation, so that owner in section 45(1)(b) meant someone with a real entitlement to possession, which in the present case reflected the defendants. And well, I don't need to go into the second leg of it, but if I can just drop down to what was held, allowing the appeals, one, in order to ascertain whether a particular statute provision imposed a charge or granted exemption from charge, the court should, one, ascertain the facts, a class of facts intended to be affected by the charge or exemption, which was a process of interpretation of the statute provision in the light of its purpose, and two, to discover whether the relevant facts looked at in the round fell within that class, which was a process of applying the statutory provision to the facts. And if I could take you to the judgment of the House of Lords, Supreme Court, at paragraph 9, which is page 822, page 822 of the bundle, page 702 of the Ramsey principle. 9. The first way in which the local authorities advance their claim that the defendants are liable for the unpaid rates relies on the approach to statutory interpretation associated in the field of tax legislation with the case of Ramsey. What has often been referred to as the Ramsey principle or doctrine may be said now to have reached a state of well-settled maturity, not least because of its restatement at the highest level in two 21st century authorities, Barclays Mercantile Business Finance and UBS. Although usually deployed in relation to tax avoidance schemes, it is not in its essentials particular to tax, being based upon the modern purposive approach to the interpretation of all legislation, one which penetrated the field of tax legislation only at a relatively late stage, see Barclays Mercantile and UBS. There are numerous authoritative statements in modern case law which emphasize the central importance in interpreting any legislation of identifying its purpose. Two examples will suffice. One is the Quintavalli, the Secretary of State for Health. Lord Bingham said, "Every statute other than a pure consolidating statute is after all enacted to make some change or address some problem or remove some blemish or effect some improvement in the national life. The court's task within the permissible bounds of interpretation is to give effect to Parliament's purpose. So the controversial provisions should be read in the context of the statute as a whole, and the statute as a whole should be read in the historical context of the situation which led to its enactment." Then in Bloomsbury International, Lord Mance said, "In matters of statutory construction, the statutory purpose and the general scheme by which it is to be put into effect are of central importance. In this case, in the area of contractual construction, the notion of words having a natural meaning is not always very helpful, and certainly not as a starting point before identifying the legislative purpose of the scheme." Paragraph 11. The result of applying the purposive approach to fiscal legislation has often been to disregard transactions or elements of transactions which have no business purpose and have as their sole aim the avoidance of tax. This is not because of any principle that a transaction otherwise effective to achieve a tax advantage should be treated as ineffective to do so if it is undertaken for purposes of tax avoidance. It is because it is not generally to be expected that Parliament intends to exempt from tax a transaction which has no purpose other than tax avoidance. As Judge Learned Hand said in Gilbert, in a celebrated passage cited in part by Lord Wilberforce and Ramsay, if the taxpayer enters into a transaction that does not appreciably affect his beneficial interest except to reduce his tax, the law will disregard it, for we cannot suppose that it was part of the purpose of the Act to provide an escape from the liabilities that it sought to impose. See also Arrowtown Assets, Lord Millet. Paragraph 12. Another aspect of the Ramsay approach is that where a scheme aimed at avoiding tax involves a series of steps planned in advance, it is both permissible and necessary not just to consider the particular steps individually, but to consider the scheme as a whole. Again, this is no more than an application of general principle. Although a statute must be applied to a state of affairs which exists or to a transaction which occurs at a particular point of time, the question of whether the state of affairs or the transaction was part of a preconceived plan which included further steps may well be relevant as to whether the state of affairs or transaction falls within the statutory description construed in the light of its purpose. In some of the cases following Ramsay, reference was made to a series of transactions which are preordained, RC Burma Oil and Furnace and Dawson. As a matter of principle, however, it's not necessary in order to justify taking account of later events to show that they were bound to happen, only that they were planned to happen at the time when the first transaction sequence took place, and that they did in fact happen. See Scottish Provident Institution, where the House of Lords held that a risk that a scheme might not work as planned did not prevent it from being viewed as a whole as it was intended to operate. And pausing there, that both paragraphs 11 and 12 were quoted by Mrs. Justice Falk in her judgment in this case, paragraphs 65 and 68 respectively. Carrying on, paragraph 13 of Rossendale, the decision of the House of Lords in the Barclays Mercantile case made it clear beyond dispute that the approach for which the Ramsay line of cases is authority is an application of general principles of statutory interpretation. Lord Nichols, delivering the joint opinion of the Appellate Committee, which also comprised Lord Steyn, Lord Hoffman, Lord Hope and Lord Walker, identified the essence of the approach as being to give the statutory provision a purposive construction in order to determine the nature of the transaction to which it was intended to apply, and then to decide whether the actual transaction, which might involve considering the overall effect of a number of elements intended to operate together, answered to the statutory description. Lord Nichols also quoted with approval the statement of Ribeiro, PJ in Arrowtown. I think I've read that out already. Paragraph 14. Almost all statements of principle, however broadly framed, tend to be responsible for the particular facts under review. The above statements refer to the transaction, and most of the leading expositions of the Ramsey doctrine do the same. This is because most of the provisions being considered taxed, or as the case may be, exempted transactions, but not all do. Some involve tax, such as stamp duty on instruments. Others impose charges by reference to the status of a person or their rights in relation to specified property, such as the owner of unoccupied non-domestic property in the present case. The Ramsey doctrine is no less applicable in such cases. In McNiven and Westman, Lord Nichols said, the paramount question always is one of interpretation of the particular statutory provision and its application to the facts of the case. No statement of the principle could be more general than that. 15. In the task of ascertaining whether a particular statutory provision imposes a charge or grants an exemption from the charge, the Ramsey approach is generally described, as it is in the statements quoted above, as involving two components or stages. The first is to ascertain the class of facts which may or may not be transactions intended to be affected by the charge or exemption. This is a process of interpretation of statutory provision in the light of its purpose. The second is to discover whether this relevant facts fall within that class in the sense that they answer to the statutory description. Mercantile. This may be described as a process of application of the statutory provision to the facts. It is useful to distinguish these processes, although there is no rigid demarcation between them, and an iterative approach may be required. According there, of course, what we say is that the purpose of the Capital Allowances Act, as we've seen Lord Nichols describe in BMBF, is to give tax relief for capital expenditure on plant and machinery when the accountant's depreciation wouldn't be so allowed. And that's what it's there for. In this case, all this plant and machinery is already qualified for capital allowances when originally acquired, and there's nothing that happens in the course of carrying out this particular avoidance scheme which could possibly fall within the purpose of Capital Allowances Act in order to give a second charge to the taxpayer. Carrying on, 616. Both interpretation and application share the need to avoid tunnel vision. The particular charging or exempting provision must be construed in the context of the whole statutory scheme within which it is contained. The identification of its purpose may require an even wider review, extending to the history of the statutory provision or scheme and its political or social objective to the extent that this can reliably be ascertained from admissible material. Likewise, the facts must also be looked at in the round. In McGuffian, Lord Steyn explained that it was the formalistic insistence on examining steps in a composite scheme separately that allowed tax avoidance schemes to flourish. Sometimes looking at a composite scheme as a whole allows particular steps which have no commercial purpose to be ignored, but the requirement to look at the facts in the round is not limited to such cases, as in thus in Scottish Provident, where the taxing statute granted an allowance which depended on the taxpayer having entitlement to a specific type of property, gilts. A view of the facts in the round enables the House of Lords to conclude that a legal entitlement to gilts generated by one element in a larger scheme failed to qualify because the entitlement was intended and expected to be cancelled out by an equal and opposite transaction. So I think I can skip the discussion about the rating legislation, rating avoidance schemes and debt, and take you to paragraph 46, which is page 832 of the bundle, or page 712 of the report, where Lord Briggs and Lord Leggett, who are giving this judgment, say summary of relevant facts. Drawing the elements of the scheme together on the agreed or assumed facts of the present case, the following may be said about the scheme leases and the entitlement to possession which the leases conferred on the SPVs nominated as the tenants of the unoccupied properties. 1. The leases were not shams and created genuine legal rights and obligations. 2. The leases were entered into and the rights under them granted solely for the purpose of avoiding liability for business rates on the part of the defendant and for no other purpose. 3, the leases were not granted with the intention of allowing the SPV to make any use of the property or giving the SPV any role in its being brought back into use. To the contrary, it was an inherent part of the scheme that the SPV would have no ability to do so. The SPVs were constituted in such a way that they could do nothing with their rights under the lease, having neither the monetary nor human resources with which to do so, or any business of which any such an activity could form a part. Those rights were accordingly of no value or benefit to the SPV. Furthermore, the SPVs were intended either to go into immediate liquidation under Scheme B or to be dissolved after a period of inactivity, which was to begin upon the grant of the lease under Scheme A. And then if I can skip down to 47, applying the legislation to the alleged facts, there could be 47. There could be no doubt that the definition of the owner of a written in Section 65(1) of the 1988 Act as the person entitled to possession of it is to be interpreted as denoting in a normal case the person who, as a matter of law of real property, has the immediate legal right to actual physical possession of the relevant property. Mrs. Justice Arden so held in Brown, City of London Corporation, a reason for concluding that the right of a receiver under a debenture to exercise the power to displace the possession of the company which was the tenant of an unoccupied property did not make the receiver the quote owner of the property for the purposes of Section 65(1) and thereby liable for business rates. It has not been suggested that that conclusion was wrong. Furthermore, such an interpretation generally accords with the legislative purpose of imposing the liability of business rates on the person who controls whether the property is left unoccupied and on whom the legislation is intended to place an incentive to bring the property back into use for the benefit of the community. 48. In the unusual circumstance of this case, however, identifying the person entitled to possession in Section 65(1) of the 1988 Act as the person with immediate legal right to possession of the property would defeat the purpose of the legislation. As we've explained, the schemes were designed in such a way as to ensure that the SPV to whom the lease was granted had no real or practical control over whether the property was occupied or not, and that such control remained at all times with the landlord. 49. In our view, Parliament cannot sensibly be taken to have intended that the person entitled to possession of an unoccupied property on which the liability for rates is imposed should encompass a company which has no real or practical ability to exercise its legal right to possession and on which that legal right has been conferred for no purpose other than the avoidance of liability for rates. Still less can Parliament rationally be taken to have intended that an entitlement created with the aim of acting unlawfully and abusing procedures provided by company and insolvency law should fall within the statutory description. 50. In these circumstances, we have no difficulty in concluding that, on the agreed and assumed facts, the SPVs to which leases were granted as part of either of the schemes we have described did not thereby become entitled to possession of the demised property for the purposes of the 1998 Act. Rather, throughout the term of the lease, that person remained the defendant landlord. This does not involve ignoring the leases in the way that an intermediate element in a circular transaction might be ignored under the Ramsey document. Rather, it involves their close examination in their context and a conclusion that they did not transfer to the SPVs the entitlement to possession required by the Act as the breach badge of ownership. If the defendants did not thereby transfer their entitlement to possession, it necessarily remained for the purposes of the Act with them. The Act requires someone to be identified as the owner, and that will be the person who, in any tenurial claim, starting with the freeholder and working downwards, has not disposed of the entitlement to possession of the property in question. Just pausing there, so we of course say on the facts of our case that we did not cease to be the owner of all our various bits of plant and machinery during the 3 or 4 weeks that these schemes took to play out. 51. We emphasise that this conclusion is not founded on the fact that the defendant's only motive in granting the lease was to avoid paying business rates, although that was undoubtedly so. if the leases entered into by the defendants had the effect that they were not liable for business rates, their motive for granting the leases is irrelevant. In order to eliminate the legal uses, in order to eliminate the legal issues, to use the words such as artificial or contrived to describe the leases, when it is now accepted that they created genuine legal rights and obligations and were not shams. Our conclusion is based squarely and solely on a purpose of interpretation of the relevant statutory provisions and analysis of the facts in the light of the provisions so construed. So we say, of course, in relation to that, on a purpose of interpretation of the relevant authority, we did not cease to own the plant and machinery when we entered into this scheme where we, for a short term, were involved in the transactions that you've seen. No cessation of ownership. If I just finish off on this case by taking you to paragraph 61, which is at page 837 of the bundle 717 of the report. Paragraph 61, it may be that other factual situations may demonstrate that this test needs some further adjustment. For example, the letting of unauthorized business property by a parent company to a wholly owned and controlled subsidiary will not of itself cause the subsidiary to fail to satisfy the ownership test merely because the management of the affairs of the subsidiary, including whether to bring the premises back into occupation, rested with the parent's board. We would, however, reject the criticism that the test is insufficiently certain. In any ordinary case, the test will easily be satisfied by identifying the person who is entitled to possession as a matter of the law of real property. The fact that the law of real property may not prove a reliable guide in an unusual case of the present kind is not, in our view, an objection to our preferred interpretation. The value of legal certainty does not extend to construing legislation in a way which will guarantee the effectiveness of transactions undertaken solely to avoid the liability which the legislation seeks to impose. And we say, by a similar token, it's no answer to our case to say that, well, there might be genuine cases where transactions are entered into which would involve the possibility of buying back an asset at some time in the future. You might be able to find a case where there was a cessation of ownership, even though there was a possibility at some time in the future of buying back the asset. That is not this case. It is nowhere near this case. This case is just purely uncommercial, short-term arrangement with no commercial purpose at all. So that's Rossendale and Hurst, but we haven't. We're quite happy to carry on. I'm happy to carry on. I don't know whether practice is courteous to have any sort of break or not, but I'm
Practice is
quite
usually
happy.
not to have a break and to
No, fine.
carry on until the short adjournment.
Yeah, good. Then the next case I'd like to show you is Clipperton, which my Lord Justice Nugee may have in memory. That is at volume 3, also at tab 49.
I don't think it was intended to say anything new.
Sorry?
I don't think it was intended to say anything new.
No, well, I don't think it does, but it...
In which
But
case, I'm not sure.
I do adopt it.
A great deal.
It does say one or two things with great respect I very, very much like to adopt. And it's extremely helpful to everybody, I would say, that to have everything sort of neatly in one place, as it were, rather than have to take you through 20 previous cases. Clipperton, well, facts are summarised by my Lord Justice usually at paragraphs 1 to 3 of this decision. But even more briefly, if I may, Clipperton concerned a marketed tax avoidance scheme designed to enable individual shareholders to receive tax-free returns on their investment instead of receiving taxable dividends. The amount that would otherwise be paid out, say £200,001, say, by way of a dividend by a trading company, which was called Win Yorkshire in this case, would instead be subscribed for a single B share in a newly formed subsidiary, which was called Win Scarborough in this case, at a premium of £200,000. So you had one share for which £2,001 were paid. So the one share was issued at a premium of £200,000. So the Scarborough B share was put into an 18-month settlement, the beneficiaries of which were largely the original individual shareholders, but importantly did include the parent company, Win Yorkshire. And so the parent, Yorkshire, then resolved to cancel Scarborough's share premium and credit the £200,000 to distributable reserves. So Scarborough then declared a dividend of £200,000, which was duly paid to the trustees, who in turn distributed it to the beneficiaries. And the tax avoidance intention was explained by my Lord Justice Nugee at paragraph 9. Well, actually, paragraph 9, what it was doing is setting out Judge Morgan, the same Judge Morgan as we have. After setting out the facts, Judge Morgan said in the first tribunal decision, I find that the sole purpose of the relevant parties in implementing the arrangements described above was to enable Win Yorkshire to provide its shareholders with the funds they received as a return on their investment in shares in Win Yorkshire without attracting the income tax charge which usually applies to dividends or distributions made to shareholders. I do not understand the appellants to dispute that this was the case. And then if I can turn to Lord Justice Nugee's judgment, paragraph 15, which is at page 911 of the electronic bundle. There, you say at paragraphs 3 and 4 of the first tier tribunal decision, Judge Morgan succinctly identified the rival arguments advanced before her. That for the appellants was that the ICARDO scheme was effective to require the income in dispute to be treated as the income of Win Yorkshire alone. This was because Win Yorkshire was the settlor of the settlement, the trust. Win Yorkshire had an interest in the settlement property, the B share, in that some of the income from the B share was payable to Win Yorkshire. The B share was to revert to it. And hence, by prisoners of Itoya, the income arising under the settlement, including that payable to the appellants, was treated for the income tax purposes as the income of the settlor and of the settlor alone. In other words, it was treated as the income of Win Yorkshire, but not of the members of the family. And carrying on there, HMRC had two alternative arguments why this was wrong, and the appellants were liable to income tax on the sums received. First, called by Judge Morgan, the Ramsey argument was based on the principle established by the well-known case of W.T. Ramsey. She accepted this argument, concluding at paragraph 114 that on a purposive approach to the construction of sections 383 to 385 of Itoya and section 1000 of the CTA, and on a realistic view of the facts, Win Yorkshire made a distribution to the appellants in respect of their shares in it by providing funds to Win Scarborough in the shape of funds used to acquire assets, in the shape of funds used to acquire shares in it, with the sole purpose of thereby enabling Win Scarborough to pay the B share dividend for the intended benefit of the appellants solely in their capacity as its shareholders. I can skip the settlements argument. This is second. You can take you through to then. If I can take you to paragraph 25. 24 is headed the Ramsey principle, and I don't think I need to take you through that. And it quotes Rossendale.
Mr. Mill, speaking for myself,
Yeah.
I've read these words several times. I don't know that it's necessary to read them out, except if you'd like to tell us which
Which paragraph?
parts to read, we could read them to ourselves again?
Well, yes, of course, if that's what you prefer. Yes.
It's slightly embarrassing hearing one's own words read.
Well,
Makes sense.
I can concentrate on 25. May I read that out, because it's not you really. It's just what you said. In the first tribunal, Judge Morgan held. And I'm very fond of Judge Morgan, as you might imagine. Judge Morgan held, applying this approach, that Wynne Yorkshire made a distribution to the appellants in respect of their shares within the meaning of section 1113 (3) CTA, and hence that the distribution by Wynne Yorkshire was a distribution out of assets of the company in respect of shares of the company within section 1001B CTA, and so was a distribution for the purposes of section 383 (1) Etoya. The Upper Tribunal agreed, holding that the FTT did not err in law in reaching this conclusion. And then I would then ask your lordships to read on.
Which parts would you like us to read?
Well, I think it's the black line bits. Lord.
So from 26 down
26
to
right through to
32. Very well, we'll do that. Yes, Mr. Well, I think.
Naturally, I invite the court to say the same as paragraph 30 starts off. Indeed, the present case would seem to be a paradigm case for the application of the Ramsey principle, and I invite the court to say what is said at 32. I consider that Judge Morgan was right to conclude in this case that there was no cessation of ownership within the meaning of section 61(1)(a). And then, if I can then move on to the even more recent Hargreaves judgment.
Just before you leave that, in Clipperton,
yes,
we had, and I accepted, a submission as to what the word distribution actually meant.
Yeah.
Something that was intended to reach and did reach the shareholders.
Yes.
Do you have a submission as to what the words cease to own? Do you have a paraphrase for the word cease to own? Or do you just simply say, on the facts of this case, they didn't cease to own?
Well, I certainly say that, but cessation, as I've said, does have to carry with it a flavour from that section 61, the other subparagraphs B, C, and D, and then section 61 of permanence. I mean, it doesn't mean a mere blip in the ownership. It means something which changes the ability of the owner of the plant and machinery to use it anymore. Because what's happening under section 61 is that the owner of the plant and machinery is then having to bring in the value of the machinery or plant that it's sold. So if it's sold, it brings in that into its capital allowance computation, it brings in the proceeds of sale. In other cases, it brings in the market value of the equipment at that time. But here, to say that because you've, I think I said in introducing, it talks about dismantling. It must mean a permanent dismantling of it. You can't expect Parliament to have said that if you dismantle something with a purpose, with the intention of reassembling it the following week, that somehow there's a disposal procedure. You've got to do a calculation. If you dismantle it, so it's out of action for 3 weeks while you reassemble it, that's what I would say quite clearly not something that Parliament intended to be a cessation and thus a disposal event within the meaning of section 61. So bearing in mind what section 61 is requiring you to do, it's requiring you to bring in a disposal value on the date of the alleged disposal, alleged cessation of ownership. And it does suggest that you're not going to be using it anymore, although as I say, conceivably you could have a situation perfectly commercial in which you did sell your equipment, but under terms when you might sometime in the future possibly buy it back again. But that's by the by. This is not that case. This is one where you're quite clearly not losing ownership even for a second. I mean, because, not losing use of the equipment even for a second. You carry on using the equipment for the purpose of the milk distribution business or whatever it is. Yeah. So basically, I would say cessation is a situation that suggests a situation where, having acquired the asset for the purpose of use in your business, and got allowances under section 11, you are now ceasing to use the asset for the purpose of your business in a way that suggests a permanent cessation.
It doesn't say cessation of use, and you can use assets without owning them,
yeah.
Undoubtedly, and presumably if you sold assets and leased them back, but with no expectation or intention to ever reacquire them,
yeah.
That would be a cessation of ownership, wouldn't it?
Yeah.
So it's part of your definition, not just that you continue to use it, but you continue to use it in circumstances where the intention is that you will reacquire dominion over them by repurchasing them. Is that?
Well, you could.
Is that what you're saying?
You could theoretically have a situation in which that might happen, yeah. But it'd be a financing arrangement there. You might have a sale and leaseback. You might be a genuine financing arrangement where you carry on.
But that would be a cessation of ownership.
That would be a disposal, a sale of the assets, yeah, which was for genuine commercial purposes and a financing arrangement. As you've heard, in this case, the finding of fact by the first tribunal was there was no question of financing arrangements here. There was no financing element of it. It was done purely.
Well, you have a finding of fact that it was, save in very unlikely circumstances, intended that the put options would be exercised and the property would be reacquired.
3 weeks' time.
Yes.
The put option would be exercised in 3 weeks' time.
I'm trying to tease out what is the construction of the statute which you ask us to adopt, and I think the answer is that you don't cease to own it if you A, carry on using it, and B, you're intending to get it back in 3 weeks' time. Is that the answer?
Well, more than intended. It's the scheme is you get it back in 3 weeks' time.
Yes.
It might be if you had a. I'm not saying that my argument would cover a situation where you do a financing transaction, sell an ordinary sale and lease back to a bank, under which you might have an option to exit, which you could exercise at any time in the future. I mean, almost by definition, if you're getting finance from a bank in those circumstances, the last thing you're going to be doing is to exercise an option to buy it back again 3 weeks' time. You need the finance, but you might just have that long stop possibility of buying back the plant and machinery if circumstances change. But this isn't that sort of case at all. We have a finding of fact there's no financing element of it. And so that's where I draw the line.
Thank you. Yes.
And then,
Is that enough from Clipperton? Do you want anything else?
Sorry?
Did you want anything else from Clipperton?
I don't think so at the moment, no. Thank you, my lord. So then the Hargreaves is the latest case. That's at tab 52.
Yes.
We have that.
Which paragraphs would you like us to look at here?
Well, I'm just going to explain what it was in brief. That the Court of Appeal upheld the decisions of the courts below that interest paid by the appendant companies on its loans was yearly interest, even though the duration of individual loans was less than a year, because the loans were routinely replaced by further loans of the same or larger amount by the same lenders. The facts are set out by Lady Justice Fout at paragraph 4, where she's actually adopting the Upper Tribunal summary of the background, which can I take you through that. The Appellants group required property primarily for property investment purposes. In the relevant period, the properties held were in the UK, such that the income and capital gains group were made in the UK. Some of the group's loan funding took the form of unsecured borrowing from directors of the group, under family members, Gibraltar resident trusts of which they were separable and or beneficiaries, and the group's FIRBs, funded unapproved retirement benefit scheme. Together they're all called the lenders. Before 2004, the loans were provided somewhat informally. In November 2004, the group restructured its loans with the intention that loan interest would not be subject to UK tax, but would still generate relief for UK companies, group companies. The new arrangements, and this is paragraph 13 of the UT, the new arrangements involved the following steps. One, shortly before the interest was paid by the group borrowing company, the relevant lender assigned for consideration the right to interest for a third party. It was initially a Guernsey resident company run by a group providing trust and corporate administration services. In subsequent years, this role was fulfilled by one of two Guernsey resident trusts after marriage, also managed by Mercator or the Guernsey Trusts. At the same time, the lender assigned the principal to another company within the Appellants group. In later years, after 2009, this step was omitted, and both the principal and interest were assigned to the same third party, Guernsey. 1 or 2 days after the assignment, the appellant paid the interest and principal to the relevant third party, Guernsey again. 4 arrangements were made for the relevant lender to advance an amount generally at least as large as the original loan amount principal to fund the above payment. Paragraph 14, interest and principal on the lender's new advance were in turn assigned as in step 1 above. The above process of assignment, repayment by the appellant and re-advance by the original lender continued throughout the period relevant to the appeal, that's October 2010 to March 2015. In relation to interest payments made from 2012 onwards, Storia, or the relevant Guernsey Trust, assigned the right to interest to a UK resident company, Humet, also managed by Mercator, with the result that the appellant made interest payments to Humet, and then the loan documentation also changed to contain terms that 1, the loan was repayable on 30 days notice by the lender or any time after by the appellant. 2, all payments were to be made in Gibraltar from a source outside the UK. 3, no assets in the UK were secured, and 4, Gibraltar law was the governing law, and Gibraltar courts had exclusive jurisdiction. The revolving facility agreements with the FIRBs contained similar terms but referred instead to Jersey law in the Jersey court. Lady Justice Clark continues, paragraph 5. There was no dispute that there was a commercial benefit in having access to unsecured finance from the lenders for the purposes of Hargreaves' business, but that the sole purpose of the refinancing structure itself was to ensure that the interest accruing on the loans fell out of account for tax purposes for the lenders, whilst the borrower's corporation tax deduction remained intact, and that there was no commercial purpose to the refinancing structure itself other than that tax advantage. So that's a brief summary of the scheme that was in front of the court in Hargreaves. And then if I could take you through the judgment. Well, with great respect, I would like to adopt the entire judgment as but particularly important in my respectful submission of paragraphs that, well, there's a lot of it. There's a section, paragraph 18 through to 30. The one where
It's quite a long passage. Do you want?
Exactly, a very long passage. But can I ask the court to read it?
We can read that 18 to
Not
30.
necessarily now, but it
Yes.
could take some time.
We-
But it's not
We will do that at some stage.
Some stage.
18 to 30. Yeah.
18 to 30. The one that starts, I cannot accept that the reference to beneficially entitled is in any sense immune from the requirement that legislation is to be construed purposefully. And it ends at 30. In summary, therefore, there's no special category of statutory concept that is immune from purposive construction. It has been applied not only to transactions but to other concepts, including entitlement and entitled. In both SBI and Rossendale, that concept was interpreted as requiring a real and practical entitlement. Lord Hoffman's distinction in McNiven between legal and commercial concepts was not intended to provide a substitute for a close analysis of what the statute means. Rather, in all cases, the court or tribunal must consider whether the relevant statutory provisions construed purposely were intended to apply to the transaction viewed realistically. Then I think I can skip the case law on beneficial ownership and beneficial entitlement, but I'd like to just take you to paragraph 65, which says, as is well established, the statutory provisions construed purposefully must be applied to a transaction viewed realistically. Rossendale reiterates that the result may be to disregard steps that are solely aimed at avoiding tax, and confirms that even legal concepts like entitled to possession can, in appropriate cases, be construed as requiring a real and practical entitlement. And we say we need here a real and practical cessation of ownership. Both Scottish Providence and Rossendale considered the concept of entitlement and entitled rather than beneficial entitlement, but in both the concept was nevertheless construed as requiring a real and practical entitlement. We are concerned with the words beneficially entitled, which, as already discussed, broadly means entitlement with benefits and cannot simply be equated with equitable ownership. Nothing in the context and purpose of paragraph part 15 of ITA 2007 indicates that the words beneficially entitled should be confined to a test of equitable entitlement rather than an entitlement which carries at least some of the benefits of ownership, consistently with the previous case law on beneficial ownership and beneficial entitlement. Further, the fact that the legislation refers to beneficially entitled makes it a clearer candidate than the legislation in either SPI or Rossendale for a construction which focuses on some form of real and practical entitlement. And just show you paragraph 70. It says that the FTT accepted that Humet did not act as a trustee, but rightly concluded that that was not enough for Hargreaves to succeed. Hargreaves was unable to establish that, viewed realistically, the transactions conferred any benefit of an entitlement to the interest. There was no evidence to suggest that Humet could have used the funds received for any other purpose, or that it could benefit from them in any other manner. there was no indication that it derived any meaningful margin or other profit from its participation in the arrangements. Further, Humet's involvement was entirely ephemeral, being confined to successive assignments of interest very shortly before the loans in question were repaid. There was no suggestion that Humet was either at risk as to the amount that might be paid, such that it might not be put in funds to pay for the assignment to it, or that it might be able to benefit from the receipt being higher than anticipated. And in the same way, we say that our giving up of ownership of this plant and machinery was ephemeral and in practical terms mattered not a jot, because we carried on using it in exactly the same way during the very short period, which could have been just 1 or 2 days, in fact fixed at 3 or 4 weeks, during which technically we were not the owner. And then 72 finally on this, I think. Parliament cannot be taken to have intended the exception in section 933 to extend the company in the position of Humet, which is involved on an ephemeral basis by way of steps that were entirely tax motivated and which has not been established as having benefited in any real sense and interest as it paid away. Humet's involvement had not only had no commercial purpose, but had no practical or real effect. We say that that paragraph couldn't very straightforwardly be applied to our situation here. There are under ground 2 from paragraph 82 onwards. There's a question of whether something is yearly interest or not, and the court dismissed the argument that, oh well, each of these loans was repaid after 364 days or something, and then replaced by a further loan from the same lenders. And they said that simply won't do. The truth was that this is a loan for a longer period than a year, and thus interest on it was yearly interest. So, with enormous respect, we say that that's Court of Appeal judgment. I don't know whether it's under appeal or not. It was only produced a few weeks ago. We'd be on this side of the court astonished if there's if they went any further. But we say that the same thinking behind Hargreaves and indeed Clipperton is entirely applicable to our situation here. I invite you therefore to say that the first tier tribunal were entirely justified in coming to their conclusion that there was no cessation of ownership on the facts of this case. So just finally, I would say that yes, the first tier tribunal held correctly that in circumstances where Altrad and Wiseman were for a ludicrously short period lessees rather than owners of the plant and machinery which they carried on using in their business in the same way as before, all as part of tax avoidance arrangements and for no commercial purpose at all, there was no disposal event being cessation of ownership for the purposes of section 61 properly construed. So on that, unless your lordship's ladyship have any questions, I would hand over to my learned friend Mr. Davey for issue 2.
Thank you very much, Mr. Mill. Yes, Mr. Davey.
May it please your lordships, may it please your ladyship, good afternoon. I'll be addressing the court in relation to ground 2. In terms of structure and terrain I intend to cover, I've got a list of 5 items in front of me. I think it's helpful if I read that list out. Number 1, there's a potential preliminary point in respect of paragraph 38 of the court's permission to appeal decision. Number 2, There's the revenues application for permission to rely on an unagreed bundle of documents. And then beyond that, perhaps more substantively, number 3, submissions regarding legislation. Number 4, submissions regarding facts. And then finally, number 5, it may be that by the time I get there, there's little, if anything, to say, but if there is, then I'll deal with it there. Perhaps we can call it miscellaneous for now. Now, those headings are not watertight. There are some points that rear their heads more than once or in slightly different ways, but I think that's of some guidance in sketching out broadly where I'm going to try and go. Just one initial point before I go further. My Lord Justice Nugee, I think, essentially asked whether ground 2 is an alternative ground. That's certainly how I understand it to be. If the court's within the learning from Mr. Milne, then I'm not needed. Familiar feeling. But otherwise, we have ground 2. Lord Justice Nugee referred to the first tier's decision at paragraph 76(2)(b) in sort of articulating this point. That sits within what was called the Ramsey issue in the first tier's decision. It's actually within the submissions section of that issue. One gets the same point as a conclusion a bit later in the decision, paragraph 260(2)(b), just for the court's note. So this is towards the end of the what's called the Ramsey issue, and at 260, you see Judge Morgan saying, in conclusion, in my view, on a realistic and unblinkered view of the facts, having regard to the effect of the composite transaction as a whole, as described above, the provisions of 61(1)(a), the relevant funding rules, or Section 11 were not engaged to give effect to the appellants. The effect the appellants said applied. 1, on the sale of the assets to SGLJ, the appellants did not dispose of the assets for disposal value for the purpose of Section 61. One can then skip forward to go to 2, over the page. 2, it follows that the granting of the leases by SGLJ to the appellants and the reacquisition of the assets on paying the option price had no consequence for allowance purposes. Viewed in the context of the overall plan, and then we can go to B, the appellants did not incur the option price as capital expenditure on the provision of the assets for the purposes of their respective trades, and they did not own the assets as a result of incurring that sum within the meaning of Section 11. So that's how Judge Morgan viewed the structure of the arguments, and I'm addressing the court on the premise that the court is against the revenue on ground 1.
Yes, so the question was, I understand that's what Judge Morgan said at 260 little 2 little b. The question was whether that was common ground, that is indeed a consequence of success on ground 1, which is really a question for Mr. Peacock. But Mr. Milne said that his understanding was that it was common ground.
Indeed, that's also my understanding,
Yes.
but I'll leave it to you. And then Mr. Peacock, if he wants to say anything different.
Thank you.
So, to the first of the 5 items I listed.
Yes.
I think the first thing I need to do is address this court in relation to paragraph 38 of the PTA decision. That's at 129 of the core bundle. So, at that point of the PTA decision, a number of submissions being put forward by my learned friend Mr. Peacock to Lady Justice Whipple and Lord Justice Nugee are being recited arguments why the granting of permission of ground 2 shouldn't be given. Now, in the event the court did grant permission, but nevertheless, paragraph 38 says this: The taxpayer's third point involves a dispute about whether it's open to this court to apply a Ramsey analysis to a part of the arrangements which were not directly challenged before the FTT, in circumstances where the FTT made findings about the purpose and nature of the arrangements considered compositely, but did not make findings specific to the part of the arrangements now under challenge. That is, in my view, a dispute of law, not fact, and it's one which the full court should determine. This court would only go on to consider the merits of ground 2 if satisfied of the revenue's case that it was open as a matter of law to this court to do so. So the question is whether it's open to this court to apply what's referred in that Commission decision as the Ramsey analysis, in considering the put option agreement and how Section 11.4 maps onto the money transfer from company to bank under that agreement. Having regard to what was argued before the FTT and what the FTT decided in the FTT decision. My submission, in short, is that it is open for the court to deal with ground 2. Essentially, there are 2 points that I'd like to make. The first concerns the nature of what is sometimes referred to as the Ramsey approach or Ramsey analysis, and the second concerns the nature of ground 2. And broadly speaking, these points tally with paras 62 and 63 of our skeleton. The first point, given the terrain covered by my learned friend Mr. Milne this morning, I think I can take, I hope, pretty shortly. The fundamental point is this: Ramsey is not something that one can, as it were, turn on or off. As has been said on several occasions, up to the highest level, the approach for which the Ramsey line of authority cases its authority is an application of general principle, which has now reached a state of well-settled maturity. Rossendale at para 9. That's how they describe it there, and in turn cite the House of Lords in BMBF, where the essence of the Ramsey approach is described in terms which I know will be familiar to this court. And indeed, they've been read out again this morning. As you know only too well, it's to give the statute provision a purposive construction in order to determine the nature of the transaction for which it was intended to apply, and then decide whether the actual transaction, which might involve considering the overall effect of a number of elements intended to operate together, answer to the statutory description.
So you have a two-stage approach, and we see that in all the recent cases. And the first stage doesn't need to be done at the first stage, but usually done at the first stages, to construe the statute. That's obviously a pure point of law. You don't need any factual findings to construe the statute. You just need argument.
Indeed.
But the second stage, which requires a realistic and unblinkered view of the facts, does require a view of the facts. And I think the concern is more about the second stage, whether we can go on and apply whatever the correct construction is to a realistic and unblinkered view of the facts if the FTT wasn't asked to take a particular view of the facts for this purpose.
Well, let me address the court on that point then. So I said I had 2 points. The first concerned the nature of Ramsey, but I think it's the central submission is that's a point of law. That's my submission, and I understand that's what your lordship is saying.
Well, the construction aspect is a point of law.
Yeah. Second question concerns what I said is the nature of ground 2.
Yes.
I think that's probably the key point. So as the learned friend's concern was articulated through paragraph 38 of the permission decision, the complaint is that, quotes, the FTT made findings about the purpose and nature of the arrangements, considered compositely, but did not make findings specific to the part of the arrangements now under challenge.
Yes.
That's the basic point. Now, I say on a proper analysis, that submission doesn't get my learned friend to where he wants to get to, i.e. to shut out ground 2 before it's even off the starting blocks. It unpacks into perhaps 3 or 4 sub-points, the submission that I wish to make. The first is this. It's key to note that as well as granting the revenue permission to appeal in respect of ground 2, this court, as part of the permission order, order that the taxpayer companies have liberty to apply to the court for, quotes, permission to admit further documents which they consider are relevant to ground 2 and which were not in evidence before the FTT. That's PTA order para 2. So, if and insofar as the concern was that ground 2 might be considered against a documentary evidential gap, this court has made clear that it would be open to an application from the taxpayer to fill any perceived gap. It's noticeable that no such application has been made. Secondly, there's the related point that the court has also ordered in considering ground 2 that it is to be assumed when the bank exercised the put options. The order actually says when the taxpayer exercised the put option, but I think everyone recognises the bank. When the bank exercised the put options, the subjective intention of the taxpayer in paying the option price was to reacquire the assets for use in their business. That is also part of the PTA order.
Yes.
Now, I'll be addressing the court in relation to that assumption in due course, or at least that's what I'd wish to do. But I do say, again, if the concern is of an evidential gap, then that has been dealt with through what this court has ordered in granting the permission in respect of ground 2. So there's an order in respect of any missing documents. Taxpayer hasn't availed themselves of that opportunity. And there's an order regarding a particular assumption that's to be made at a particular point. So that's my second subpoint. My third subpoint here is that if and insofar as my learned friend's complaint includes a contention that there was some flaw in the FTT's approach to the facts, in viewing the arrangements and events that occurred as linked to one another, when what was required, according to the taxpayer, was a more granular analysis and more specific findings in relation to particular elements, then I say that contention should be rejected, or at the very least, I say it falls to be considered in the context of this court hearing ground 2, rather than as a basis for this court not to hear ground 2 at all. Put shortly, the reason that my learned friend's submission should be rejected is that it erroneously assumes the very point in issue, because it's of the essence of the unblinkered approach which the Ramsey vein of authority demands, that the question of how most appropriately to analyse a particular fact pattern the altitude or proximity of analysis, if you like, married up with the purpose of construction of the relevant legislation, will depend upon the character of the particular fact pattern in issue. That's a point that Lord Hope makes in relation to this very section, section 11.4, in Tower, at paragraph 88, where he says that the extent and depth, he puts it, the extent and depth of the factual inquiry will always depend on the circumstances of each case. Paragraph 88, Tower. Now, in this case, the FTC was clear and the Revenue Submit correct in its view that it was looking at a series of inextricably linked steps, and therefore a proper analysis of the arrangements would include giving due weight to that fact. Rossendale at 12, if one wants to anchor that in the jurisprudence. And against that backdrop and in those circumstances, insofar as the taxpayer is contending that what was needed and what was missing at FTT level was, if you like, an isolationist approach, looking at the put option in isolation, my submission is that's wrong as a matter of principle, or again, to put it at its very lowest, it's a point to be explored in the context of this court considering ground 2 rather than deciding not to hear it at all. The fourth and final of my sub-points here is that it's important not to lose sight of what the FTT did find. The reason I say that is that although in granting permission for ground 2, this court has decided that it is a new ground of appeal, PTA decision para 31, there's no suggestion in the granting of permission on ground 2 that any findings of the FTT are to be considered, as it were, airbrushed when it comes to this court considering ground 2. And indeed, the UT's decision states that the FTT's findings were, quote, unchallenged. Upper Tribunal decision 96. So although it is said on behalf of the taxpayer that the FTT, again quoting from PTA decision 38, did not make findings specific to the part of the arrangements now under challenge, I say that's not correct. It did make findings, and if I may, I'll flag a small number of examples. So if the court has the FTT's decision to hand, perhaps we might start at para 255 on page 253 of the bundle. And I'll just, if I may, just read out a handful of passages. It may be that some have been heard this morning, but nevertheless I think it's useful. 255, from the outset there was no real doubt, and so just to be clear, this is within the decision section, which starts at paragraph 230, on the Ramsey issue, which starts at paragraph 76. So that's where we are in terms of the judgment. 255, from the outset there was no real doubt that the appellant's respective groups would reacquire the assets at the end of the lease periods, given the put and call option mechanism and the ongoing need for the assets for use for the relevant group's trading purposes. For the reasons set out below, barring wholly unexpected events, the expectation was that the reacquisition would take place on SGLJ exercising the put options on expiry of the lease periods. If we go over to 256, this begins, each step involved in the transaction was carefully constructed to achieve the desired result from an allowance and funding perspective as follows. And then sub 1 concerns what was intended. It was intended that on the sale of the assets of SGLJ, and then we have at A, for allowance purposes, the appellants would thereby cease to own the assets under 61(1)(a), so that when, as planned, they reacquired the assets only 3 or 4 weeks later, they could claim that for the purposes of Section 11, in paying the option price, they incurred fresh qualifying expenditure. A little further down at B, for funding purposes, the appellant would receive sale proceeds which would be sufficient to fund the option price, due when, as planned, the put options were exercised. It was integral to the operation of the plan, therefore, the appellants would not have to put their hands in their pockets to fund the supposed qualifying expenditure. And then within sub 2, which begins as regards the grant of the leases and the put options, if we go to C, please, that's at the foot of the page. The put option was also the mechanism put in place to enable the appellants to reacquire the assets, thereby generating the intended qualifying expenditure in the form of the option price. It was essential that the acquisition took place under this mechanism. It was only on that basis the option price would be taken into account in QA in the disposal formula. Over the page at sub 3, all the steps set out above were put in place, therefore, so that when the appellants reacquired the assets pursuant to the put options, they could A, fund the option price with the sale proceeds received on the initial sale for SGLJ, B, claim the option price constituted qualifying expenditure within the meaning of Section 11 257, we then have the paragraph reading, as noted, Mr. Peacock submitted that the exercise of the put options was not inevitable. The call options were required to address a real commercial risk, and the SGLJ would not exercise the put options. However, 2571, given the very plain purpose driving this planning and the nature of SGLJ's role within it, it seems highly unlikely that SGL would not have exercised the put options, as in fact it did, to recoup the temporary finance provided to the appellants and thereby to ensure that the purpose of the scheme was achieved. At 2572, moreover, there was an incentive for SGLJ to exercise the put options, given that under the Wiseman transactions, SGLJ was entitled to its second arrangement fee only if it exercised and duly completed the put option. And perhaps we go right to the end of 257, final sentence of 2575, there is no doubt that it was intended to operate on the basis that SGLJ would exercise the put options. If we could go a little further on to 265, page 258, para 265, unlike in BMBF and Simon Tower, as set out in full above, the appellants had no commercial or business purpose at all in entering into any of these steps. And the reference to these steps, plural, expressly includes the option price. We see that from 264, the immediately preceding paragraph. So, I do say that the idea that the FTT did not make findings specific to the put option is not right if one reads the decision. And indeed, there are other passages I could go to as well, but I hope I've made the point through the passages that I've cited. Making the point slightly more broadly, my submission is that the idea that there is just some void when it comes to the put option, which means that this court is not in a position properly and fairly to deal with ground 2, I do say is demonstrably incorrect and should be rejected. My learned friend has the order in his favour to the effect that the court would be amenable to an application to produce further documents, and that option hasn't been taken up. The learned friend has the option assumption, which we'll explore in due course. And we have the FTT making the findings that it has, and I've cited some of them to you there. And we also have, as I say, the point that insofar as there's a question of whether the FTT didn't do things in the right way, I do say ultimately that is a legal point. It is a question of whether Judge Morgan was right or wrong in the analysis she adopted. That's not an evidential point, it's a legal point. And so, taken together, my first point about the very nature of Ramsey, my second point about the nature of ground 2 and what this court has done in relation to it in granting permission, and what the FTT did in relation to the put option in making the findings that it did, I say it is proper, appropriate, fair for this court to hear submissions on ground 2. Whether the court is with me on ground 2 is a different question, of course, but the idea that in this sort of case, with this sort of scheme, and against the backdrop of the Ramsey terrain and the orders of the court in relation to granting permission, the idea that it's not even open to explore ground 2 before this court, I do say should be rejected. I mean, we're going to come back to it, I think, probably more than once, but one other passage that I haven't taken you to, 75. My view is that it's plain from the design and economics of the scheme that the appellant's sole purpose in entering into the various transactions was to obtain allowances on the option price without suffering the economic burden of paying that amount. So the option price was a part of the argument at first instance. This court did find that ground 2 is a new ground. I'm coming before you with a new ground, but it's not that it was absent. It was there, And for the reasons I've given, I say it is appropriate and fair that I at least be heard on ground 2. Where we get to on it is another matter. Those are my submissions on that point. I don't know whether...
We think we'd like to hear you on a provisional basis. We're not going to give a decision now as to the point you've just addressed us on.
I'm grateful for that.
We obviously will hear what Mr. Peacock wants to say about that.
Thank you. Well, in that event...
So the fact we're proceeding to hear you doesn't mean that in the end we will accept it. It was open to you to take the point. We'll hear.
Your Lordship's been crystal clear. I fully understand the footing on which I'm allowed to address the court.
Yes, thank you.
I said there were 5 things I needed to do. We've done the first of them. I now move on to the second, which is our application for permission to rely on an unagreed bundle of documents. May I just check that the court has before it what would be useful to have before it, the unagreed bundle?
That is unagreed supplementary bundle.
Yes, that sounds promising. And does the court have the revenues short 2 or 3 page document provided in support of the application?
I'm not sure that I have seen that. No, I don't think we've seen that.
Okay. We do have some spare copies. If it's okay, I'll hand them up. Yeah. They didn't see them? No. Well, my apologies. An application was made.
You haven't seen this either, Mr.
I
Peacock.
haven't, but it may help my life. And we're not going to seriously object to this court looking at what's in the unagreed bundle. I have submissions to make in due course about the relevance of those documents. There is a point of principle as to what is appropriate and not appropriate for bundles in this court, but I'm not inviting you to make any major decision of principle about this particular issue.
Well, that's very helpful. Thank you very much.
Well, I'm grateful to my learned friend's indication. I'm in the court's hands.
I think we'd probably still like to see your document.
I think that's a fair request.
And I think Mr. Peacock would probably like to see it as well. Yes.
It's certainly a fair request.
And I mean, is there an application as such?
There is an application.
Is that in the bundle? I'm sorry, I haven't.
My apologies if it's not in the bundle.
I think it's just been handed up to us with your...
It was made within the required time under the relevant practice direction. I do apologise if it's the first time your lordships and ladyship are looking at it. I mean, there are various ways to proceed. One way to proceed would be to ask the court if the court would be willing to read. It's a 2.5 page document.
Let's read the document then, please. Yes, Mr. Daly.
I'm grateful. Hopefully, to an extent, the document speaks for itself. But
Can I take it that these documents were all before the FTT?
yes, they were all before the FTT. I mean, this is a case where both sides agree there should be a supplemental bundle, and the unagreed bundle, if one disregards a very long list of lorries, it comprises 89 pages. On that footing, it's about a 15 or 16% addition to the supplemental bundle. All of it was before the FTT and the UT.
It's not just a question of numbers, it's a question of as Mr. Peacock suggested in principle, we don't hear appeals on the facts in this type of case. We hear appeals on points of law. The facts are for the fact-finding tribunal, which is the FTT. If you have factual findings, you can rely on them. If you don't, you can't really ask us to make factual findings. Is that fair?
It is fair, subject to what I would say, which is this. This is a new ground of appeal. The court was very much aware of that in granting it and made the orders which I've referred to in terms of at least being open to the idea that there would be further documentation before the court, and also granting that a particular factual assumption be made in relation to a particular element of the scheme. Yes, we have the FTT decision, but it's not, and the UT decision, but I do say it's not uncommon, indeed the rules recognise that there'll be cases where it's appropriate to have further documentation. And in this case, the thrust of my submissions, it won't be a surprise to the court here, is that one has to understand the full colour of what went on. If you want to understand why particular events took place or transactions were entered into, it might not be a bad thing to see the board minutes, for example. It's that sort of submission that I would wish to make, and I can do it in more detail if it'd be helpful. I can go to particular documents. But if we have a single mantra in this case, essentially it's that context matters. And I don't go to any of it in order to undermine anything that was said in the FTT decision, but I do say that it's not inappropriate to see the three dimensions of a particular point using documents that were before the first instance tribunal in a case such as this, on a new ground, where permission has been granted in the fashion that it has. I can do it in more detail if...
I remember it, the permission was granted on the back of your submission that it was all a question of law anyway. And that was the point. You said it's just it's a submission of law, we can deal with it on the law. And my understanding at the time was that it was on the basis that we would not have to sully our hands with the evidential material because we're not in a position to do that. And it was to protect Mr. Peacock and his client that we then made the assumption that we did and let him put in any further documentation, very much with a view to seeing what came. I don't think it was in anybody's anticipation at the time that it would be HMRC that was trying to put in more documentation to support its new ground of appeal.
I totally appreciate that, my lady. As I say, this is a case where both sides agree there should be a supplemental bundle, and these are items which agreement couldn't be made on. So both sides say there should be additional documents before the court, and this is that handful of documents where there couldn't be agreement, but where I say it is still appropriate.
You want to refer us? I'm speaking for myself. The starting point is the powers of this court, which I think it arises out of a Tribunal's Courts and Enforcement Act, which is what is the nature of an appeal to this court. And I think, unless I misremember, it's only an appeal on a point of law. Am I wrong about that?
No, you're not wrong about that.
That means that we do not exercise any fact-finding jurisdiction ourselves. I mean, there's a difference if we allow an appeal. There's no question of what we can do and so on and so forth. But when we're considering whether to allow an appeal, the question is whether there's an error of law. Now, it's one thing to say, here's a factual finding of the FTT that the advice from the professional advisors support my conclusion that X. In those circumstances, there would be no difficulty, to my mind, in you showing us the actual advice that the FTT was referring to, because that's fleshing out its factual finding. It seems to be quite a different thing to say, well, the FTT said this, and now we want you to say, for you to infer a new fact, which the FTT has not found. And once you start doing that, I think you're taking us outside what is our proper role on an appeal of this sort, and indeed it illustrates why it's unsatisfactory for it to be advanced as a new point. So I think, as my lady says, the new point for which you have permission is on the premise that you're not inviting us to make, and indeed you can't invite us to make any new inferences of fact. So maybe we'll come back to this at 2 o'clock, but I'm tempted to say, if what you're doing is showing us what the FTT had in mind when they said things, that's one thing. But if what you're asking us to do is for us to start making our own inferences, that's a rather different thing.
Well, if I may just come back to one point there. Your Lordship gave the example of it being okay to show this court the professional advice referred to in a lower court decision. That is an example of something that is in this bundle.
Yes. Well, should we, unless you want to say anything more, should we pause there, resume at 2 o'clock, and we'll see what we think about this.
All right.
2 o'clock.